Good morning, afternoon, or evening, and welcome to Copyright 101. This lesson is meant to provide you information on the basics of copyrights. This lesson was created to fulfill a requirement for Capella University ED 7503 Instructional Media Tools. During this lesson, I will be discussing the following topics. So let's get started. So I'm sure you've seen this symbol before, and I presume you know that it represents that a piece of work is copyrighted. But what exactly does copyright mean? A copyright is merely identification that a particular item is protected under the intellectual property laws against its unlawful use. Intellectual property is divided into three categories: copyright, which protects expression; trademark, which protects names; and patents, which protect ideas. So let's break that down into, say, a relevant example. Let's pretend that Michael Sanders, your humble facilitator, is a world-renowned inventor. One day I discover a process for getting that last little bit of ketchup out of the bottom of the bottle through the use of my invention, the ketchup-onator. The ketchup-onator becomes an overnight sensation, and eventually I write a book titled "The Poor Boy Who Lives Next to Donald Trump," on how I went from a kid who grew up in foster homes to living next door to Donald Trump. So, using our three categories of intellectual property protection, the invention is protected through a patent, the name, ketchup-onator, is protected under trademark protection, and the book is protected under copyright protection. But copyright protection isn't just for literary bestsellers like me. The Copyright Act of 1976 states that the items of expression can include literary, dramatic, and musical works, choreography, graphic and sculptural works, audiovisual works like this video, sound recordings, and architectural works. An original expression is eligible for copyright protection as soon as it becomes a tangible form. So, just because you thought of a ketchup-onator before I did doesn't entitle you to trademark, patent, or copyright protection. You have to actually create the individual tangible item protected under the specific categories. So now you've created the tangible item, your New York Times bestseller. What's next? Well, although the Copyright Act provides you protection for your intellectual property, in order to do so, you must first register it with the U.S. Copyright Office. Registering it offers you two primary things: ability to sue and statutory damages. You cannot sue someone for copyright infringement unless it has been registered with the U.S. Copyright Office first. You must register within 3 months of the first publication, or, at a minimum, prior to the actual infringement in order to claim statutory damages. So, when you fail to register your literary masterpiece about living next door to Donald Trump, but your roommate finds your plans for the ketchup-onator and writes the book before you do, then you have no recourse to sue for statutory damages. At this point, you may be able to seek actual damages, which often are minimal. So, how long exactly is your literary masterpiece covered under the Copyright Act? Well, before we get into that, let's discuss two other important aspects of copyrights: fair use and public domain. The term fair use, when it comes to copyrights, basically states that it's not copyright infringement if reproductions of copyrighted material is used for the purpose of criticism, comment, news reporting, teaching, including multiple reproductions, scholarship, or research. So, when the literary critic from the Los Angeles Times reproduces portions of my beloved "The Boy Who Lives Next Door to Donald Trump" and paste it all over page B12 of the early morning edition of their newspaper, informing the public of what a great novel it is, this is not copyright infringement, and I shouldn't get my lawyers all excited unless they say the novel stinks. Then that's a different story. Public domain is a little more complicated and includes several categories. Originally non-copyrightable items, lost or expired copyrights, government documents, and copyrighted material that is given to the public domain by the author. The first is originally non-copyrightable. This category includes those items that, because of their nature, are not entitled to copyright protection to begin with. Items such as facts, titles, or names. These items are automatically in the public domain and have no intellectual property protection under the Copyright Act and thus can be used by anyone. The second category is lost or expired copyrights. While it is very difficult to lose the rights provided under the Copyright Act, there are some situations where this may be the case. According to the Cornell University Copyright Information Center and a chart produced by Mr. Peter Hurdy in 2014, a copyrighted web page, by the way, any work published before 1923 has a copyright that has expired and thus is considered in the public domain. Also, any work that was published between 1923 and 1977 that were not published with a copyright originally is also considered in the public domain due to failure to comply with required procedures. Any works published between 1978 and March 1st, 1989 that was not copyrighted previously was given a 5-year grace period to either obtain a copyright or the material was placed in the public domain. So as you can see, there are a number of stipulations concerning whether or not a work is copyrighted. Thirdly, government documents. Government documents, such as the Copyright Act itself, are considered in the public domain and are free to copy, use, and distribute without reprisal. With all of that said, it's important that you ensure you research whether an item is protected under copyright before you improperly use the material without authorization. So, now back to how long your literary masterpiece is protected under copyright protections. There are a number of factors that determine the length works are protected, and depending upon the situation, there are a number of different expirations. The Peter Hurdy 2014 chart that I discussed earlier, that's posted on the Cornell University Copyright Information Center, lays out the specific categories, such as sound recordings and architectural works, whether the work was first published in the US or abroad, and some special cases. So I encourage you to check it out. The website is posted here for your use. But for the most part, the basics say that a work is protected for 70 years after the death of the author. If the work was produced by a corporation, then it is protected for 95 years from publication, or 120 years from when it was created, if it was never published, whichever comes first. So, as you can see, there is a great deal of protection for copyrighted material that lasts for a significant period. Now that we've discussed what the copyright law is and some of its components, let's take a look at what this means to you as an instructional designer. Instructional designers are the creators of courseware that take multiple types of media, images, video, audio, text, and integrate them together to make an effective and interesting course. Utilizing any of the media types stated that are reproductions, derivatives, or transformations of copyrighted material without the written permission of the copyright holder creates a situation that may lead to copyright infringement and, even worse, potential legal actions. Copyrights don't mean that you can't use the selected media. It just means that you need to get written permission from the copyright holder before using it. Depending upon your situation, often copyright holders will allow the use of their material, sometimes without charge, as long as they're given the proper credit and are clearly identified as the source of the media. But that is a choice they get to make, not you. And it's something that must be negotiated before the use of the media. Utilizing what you learned in this lesson and doing proper research concerning whether or not the media you wish to include in your lesson is copyrighted can save you not only a lot of time, but could also potentially keep you from committing copyright infringement and potentially even some legal action. Well, that just about wraps up this lesson on copyright protections. During this lesson, we discussed the three categories of intellectual property protection, what tangible items are covered under the Copyright Act, actual and statutory damages, fair use, public domain, how long items are protected, and some of the impacts of copyright laws on instructional design. As stated earlier, always ensure you properly research whether any material you are going to use is protected under copyright protections before you use it. If you need or want more information concerning the topics covered in this lesson, please check out the following references used in this lesson. Thank you for participating and have a great day.